All right, we will be on the record. State of Idaho versus Lance Jonathon Broncho, CR 1024-2407. I have Randy Neal on behalf of the state of Idaho. I have Mr. Broncho here, along with his attorneys, Jim Archibald and John Thomas. We are set for a sentencing today. Mr. Archibald, are we proceeding with sentencing today?
Yes, Your Honor.
All right. Mr. Broncho, I just want to review a little bit of the procedural history of your case before I turn it over to your attorneys, the state and the state attorney for comment, recommendation, and any other statements. You were originally brought before me May 13, 2024, and at that time you had been advised and information had been filed against you alleging you committed crimes in the state of Idaho. Those crimes included murder 1, aggravated battery, use of a deadly weapon or instrument, robbery, burglary, unlawful possession of a firearm by a convicted felon. You pled not guilty to those charges, but you returned to my court August 12, 2024, and pursuant to a plea agreement you reached with the state of Idaho, you pled guilty to count 1, which was the murder 1 charge. You also pled guilty to count 2, which was the aggravated battery, use of a deadly weapon and instrument. In exchange for your guilty pleas, the state of Idaho agreed to dismiss the remaining charges. The state also agreed it would not seek the death penalty as a sentence recommendation, and that they would recommend a specific sentence, a unified sentence of life with no more than 35 years as a determinate sentence. You agreed you would pay full restitution for these matters. You also agreed that you and your attorneys would recommend I sentence you to a unified life sentence with no less than 25 years being served as a determinate portion of the sentence. This plea agreement was non-binding on the court. Following that change of plea, I ordered a pre-sentence investigation report as well as a psychological evaluation be prepared. Those reports were filed with this court October 2nd, 2024. Mr. Broncho, have you had an opportunity to review those reports with your attorneys?
Yes, Your Honor.
All right, Mr. Archibald, anything in those reports that need to be corrected or clarified?
No.
Any objection to the court relying on those reports for purposes of sentencing?
No objection, Your Honor.
All right. Mr. Broncho? Mr. Broncho, do you still intend to stand on the guilty pleas you previously entered?
Yes, Your Honor.
All right, thank you. With that, Mr. Archibald, do you have any witnesses?
Not today, Your Honor.
All right. Mr. Neal, do you have any witnesses or victim impact statements that you would like to present?
Yes, Your Honor. We do have, and help me, how to pronounce that correct? I hope I got close. We are in the courtroom today. We did give the opportunity to read this herself. However, she's requested that someone read it for her, just given the impact that it has on her to do so. So
All right.
we would ask Pam Millhouse from my office to do that.
All right. Millhouse, go ahead, and if you feel more comfortable, just go ahead and sit. Just make sure you're close enough to that mic that we get an accurate record.
The impact of this crime has been very challenging for both myself and my son. We lost our home the night of the incident. We didn't want to go back there for fear of someone coming after us, as well as we both lost someone very precious to us in a violent way. The love of my life, and for our son, his father, Eric, was his stepdad for 22 years. The place looked like something out of a horror movie, and it still gives us both nightmares. For the first 2 months, we stayed in Airbnbs and moved every couple to a few weeks until it was warm enough to stay in our motorhome. Being so displaced was very stressful. We finally moved in there in May. There was limited electricity and no running water. So it was very much like camping, but at least it was our own place and not as expensive as the Airbnb. During this time, both and I were always on edge, fearing someone was coming after us. My son slept with the shotgun loaded next to his bed every night. Every noise made us relive the incident and became very paranoid that someone was outside. We both have trouble sleeping and have reoccurring nightmares of similar situations of being invaded at home or being shot at. We both have anxiety, which has never been something we had in the past. As soon as dusk arrives, we become on edge. Going to sleep and staying asleep are both issues, and that becomes extremely exhausting. I stayed in the motorhome all summer until mid-August when I found an apartment. I had to have two emergency surgeries, one on his fingers and one on his leg. He had the tip of his ring finger amputated and lost his nail bed. The middle finger hasn't been able to fully open since the incident. This has impacted his self-esteem and also caused him to miss out on many things like work and his training for jiu-jitsu and MMA. Just recently, his ring finger became infected due to the nail bed coming back in unexpected places. He is now being treated with antibiotics because the infection started to eat at his flesh. We're waiting to find out if the infection is in bone. We are both scared that he may need another surgery. He has been in Alaska for work since June and will be home in a week. Our health insurance is here in Idaho, so these bills from seeing the doctor in Alaska for an emergency situation will not be covered from our health insurance. During the time I was released from the hospital, I was his caretaker. I wasn't able to work because he needed constant care. We went to trauma care 3 times a week for wound care, and he was on about 6 to 7 medications that needed a strict schedule. He needed assistance getting dressed and help to use the bathroom. I estimated I lost about $5,000 in wages for the time I wasn't able to work. Another traumatic event from his injuries was that before the surgery, the medical staff gave him fentanyl. I know this is used in hospitals, but I only know that it is dangerously addictive, and we lost my brother in November of 2023 from a fentanyl overdose. So I was worried that my son was going to have a reaction or become addicted to opiates as they prescribe pain medication too. Everything felt so traumatic. I felt like my life was just unraveling at the seams and I had no control over the outcome. Most of the medical bills have been covered from our insurance. We are still working things out with victim services to see what we may owe out of pocket. The psychological impact has been overwhelming. I have been seeing a therapist and have been diagnosed with PTSD. I used to have a great memory, and now the brain fog is so bad, it's hard to remember what I did yesterday, let alone keep organized with simple things like opening mail. I'm depressed, and some days I think it would have been easier if I didn't make it that night. Life is so much harder now. I'm not suicidal. I would never do something like that. I'm just making a point on how hard life has been without Eric. We were a team, my love and my best friend. We really enjoyed being together even after 22 years. We were still excited to spend time with each other. We worked hard and had dreams and plans together. Now I don't know how to make a life without him, as my plans consisted of him in it. My son lost his father. He would fish with him every summer in Alaska. They were a lot alike, even though they were not blood related. I would call him when he was overwhelmed or stressed about something, and Eric would talk him through it. They were close on a level that a father and son are on. He struggles with the loss of Eric daily. In his words, I lost my father, who in my eyes was the greatest person to ever live, and it's incredibly hard to wake up every day knowing he no longer exists. We're attending a brain rehab with Dr. Justin Hammond. It's a week-long intensive treatment for PTSD and our individual symptoms. The cost is $3,000 a person. We hope to get relief from the paranoia, anxiety, disturbing and repetitive thoughts, brain fog, and sleeping problems. It's hard enough to grieve the loss of our beloved Eric, let alone feel the anguish of symptoms every day. We still have to work and continue to live, So hopefully we'll get some relief from this therapy. I know the therapy won't erase our memories from this tragic event, but at least we can have an easier time getting through life without Eric.
Thank you. Any other statements or evidence at this time, Mr. Neal?
No, Your Honor.
All right. Mr. Archibald, comment, recommendation?
May I remain seated?
You may, it'll actually be better for the record. Thank you.
Your Honor, this obviously is a difficult case, difficult for my client and his family, and also difficult for the victims who are here today. We believe the plea agreement that we entered into reflects that difficulty. We're asking the court to accept the plea agreement and impose a sentence somewhere between 25 and 35 years in prison before he's eligible for parole, and with the tail up to life. So here are reasons why I think the number should be closer to 25 years rather than 35 years. The sentencing criteria for this court, as we all know, is how do we deter individuals and the public from this behavior? How do we rehabilitate defendants? How do we punish them? And how do we protect society? I believe a sentence of 25 to life would achieve those goals. It's clear from the records, both the pre-sentence investigation report and the psychological assessment, that my client has had a tough time. He's had a rough life, it is fair to say. His juvenile history started even before he became a teenager. Mental health diagnoses started at a young age. His incarceration started when he was 13. So those juvenile records demonstrate a child in crisis. And the system did attempt to do what they could for him. And he has no complaints about his treatment in juvenile court. He, with his upbringing and with his challenges, he still today, he has a good attitude of hoping that he can make this right, hoping he can make it right with society so that someday he can be out again to show that he can be responsible. He has a mental health history, PTSD. The reports talk about that trauma that he suffered as a child. Talk about his substance abuse. He was 22 years old when this happened. And he had already been diagnosed with abuse of marijuana, of alcohol, of methamphetamine, and of opiates. And so a young man trying to find his relief through substance abuse, and it just did not happen. In fact, he became more irresponsible with the more substances he used. In fact, I would venture that this event would not have happened but for him being under the influence of probably all four of those substances on the night in question: methamphetamine, marijuana, alcohol, and opiates. So, what can the court do? Well, the court can protect society from Lance, protect him from himself for at least 25 years. The court can punish him for 25 years for what happened on this night. The court can also rehabilitate him and deter him. And so what kind of rehabilitation will he get in prison? This psychological assessment talks about he needs some time in prison to demonstrate his maturity, reliability, insight, and commitment to a pro-social lifestyle. So can you do that in prison? Yeah, you can. You get opportunities to show that you can be on good behavior. You get opportunities in prison to show that you can be on your bad behavior. And that's the goal, the job of the parole board when if this court gives him a sentence of 25 to life, in 25 years, they'll prepare a report for the parole commission members. That report will show the parole board what Lance has done to demonstrate his maturity, reliability, insight, commitment to pro-social activities. And so if he's been a problem in prison, which problems started out in the local jail here, if he keeps that up, the parole commission can keep him for up to life. If, however, he demonstrates that he has turned a corner and he's been responsible, then they may grant him parole in 25 years. So that's why I'm asking the court for a 25 to life sentence, because then it gives my client incentive to do as much as he can, as many good things as possible in prison. And so those will be little steps, they'll be baby steps at first, but at least he'll be able to show that, yes, I do want to get out of prison someday, and I do want to show that I can be responsible. So if this court gives a fixed life sentence, he has no motivation to do what's right in prison, no motivation to help other inmates, no motivation to help himself. So that's why I believe that the 25 to life can meet all the criteria of a sentence. It can punish him, it can protect society, it can rehabilitate Lance, and it can deter him and others from this conduct. So, Your Honor, we're asking the court to follow the plea agreement and impose a sentence of 25 to life.
Thank you, Mr. Archibald. Mr. Neal, on that recommendation from the state.
Thank you, Judge. This is not about the job that the parole board will do in 25 or 35 years. Today, it falls upon the shoulders of this court. It is not one of the goals of sentencing to try to get a defendant out of prison as soon as possible. The decision that's made today isn't about protecting the community today. By the time that the eligibility rolls around, many in this room will be dead. We have babies being born today that will be reliant upon the decision today for protection. They'll be adults with their own children. And that's the kind of gravity we have when it comes to the sentencing of somebody who is as dangerous as Lance Broncho. I'm not sure in 42 years I've encountered somebody as dangerous. And that's the nature of what is put before this court today. You know, I look at the sentence that was received by Mr. Broncho for stabbing a man multiple times. 4-year sentence. and federal court. He did not do well in prison, and he was released. And as a result, on March 9th, he walked into a young family's home, not that young, I mean, Eric was 51, and the intent was to rob them. When they resisted, of course, he was put to the test. Was he really willing to kill? And the answer clearly was, yeah, I'm going to. I'm going to pull the trigger. And that had to do with him and his own selfish motivations that day to get away after he had begun this confrontation, this incident, through no fault of the victims at all. Eric Leask is dead. He will not share Gina's life or Ormed's life. He will not, he won't have any of those things that he was living for, because a person who broke in with a gun decided that he wouldn't just give up. He wouldn't realize, no, I want to take this to the next level. He said instead, I already decided instead I'll start shooting. And not a couple of times, a lot. With a large caliber gun, the result is not just the death of Eric or even the injuries of Ormed, but that continuing wave of consequences that affects everybody around Eric and Ormed. I don't know what the federal judge had in mind, but I'm sure that throughout, a lot of these issues have been raised to the court about how terrible his childhood was. But you know, a lot of people have had really bad childhoods. The LSIR, which is the level of service inventory that has to do with recidivism, has 54 questions. The highest score you can achieve is 54. And Mr. Broncho has 42. His first arrest and conviction at 2 years old for aggravated battery, according to his own recollection. He served terms of probation, violated supervision several times. He was sentenced to time in the Juvenile Correction Center and the 3B Detention Center, but that was after an opportunity to attend and work with the Juvenile Mental Health Court. After becoming an adult, shortly after becoming an adult, he was sentenced to federal prison. He spent 2 years in maximum security, not because he was sent there originally, but because, based on his report to Dr. Lander, page 3, he was in the federal prison system where he was initially placed in a medium security federal correctional institution, but admitted that he was sent with a mission. He further explained that there was an inmate at this facility who was a sex offender, and the defendant was enlisted to engage in violence towards this individual, which he did by putting a lock in a sock and hitting the inmate in the head. This led to increased security classification and transfer to a high security federal penitentiary. At this facility, he reports associating with a gang. Page 6 of the PSI, he describes that he's just a lowly soldier in the Gangster Disciples. The new chairman of the Gangster Disciples focuses on loyalty, knowledge, wisdom, understanding, and honesty. The defendant follows those tenets. He gets his values from the head of the Gangster Disciples, a violent prison gang. After being arrested and within days of being incarcerated at the Bonneville County Jail for this offense, he was found with a contraband, which was a form of improvised weapon. He was also put into segregation after fighting with deputies. He's been in maximum security since March as a result. In his comments about this particular offense, the assault and battery on the officers, he bragged about it. He bragged about how he was disrespected. He bragged about how this would lead to him having more respect in the prison or the jail setting. This is an individual that has been diagnosed with many mental illnesses, but it seems to be very inconsistent. Dr. Lander says that it's unquestionably a very complex situation. He's been diagnosed as paranoid schizophrenic, fell into psychosis when he stopped taking medication and started using methamphetamine instead. His later diagnosis included schizoaffective disorder and bipolar with schizophrenic traits. He's claimed auditory and visual hallucinations that began when he was very young. PSI on page 7 notes the risk of reoffending without adoption of entirely new patterns of thinking and behaving is high, and the current indications are that he is not motivated for change. His alcohol use began at the early age of 8 years old. He was drinking regularly by 13. Says it's been problematic throughout his lifetime. He drinks to intoxication every time he used alcohol. But he says he's unsure if he wants to stop drinking. I'd like to, but I also like to drink, so I don't know. IDK is what he wrote. He started smoking marijuana at 8, used several times throughout the day. Methamphetamine use began at 50. Multiple use during the day via smoking, IV injection. His last use was at the time of this incident. He reported that he's experimented with heroin, cocaine, hallucinogens, prescription medication abuse without regular long-term use. He's sold drugs to maintain his high or bartered his skills of art while locked up. And he says, I'm not ready to stop. He says, I'm not ready, this is page 10, I'm not ready to stop using because I like to avoid my problems. These started early. He was suspended in elementary school numerous times for fighting. Has a weak work history because of ongoing criminal behavior and frequent incarcerations. Page 11, it's cited under the psychological assessment, there's no stated motivation for future abstinence or indication to forego use in the future, even if the motivation increases. Now on page 12, there's an extensive prior record. It involves assault at a very, very early age and detention. Multiple juvenile offenses that would have been felonies. He had multiple, 7 probation violations while on juvenile probation, and this resulted in him being confined to committed to JCC. And then upon release, or actually during his incarceration as a juvenile, then he had the charge of assault or battery upon one of the detention folks there. Upon his release in July 2020, he was convicted of the assault resulting in serious bodily injury. And then, of course, this is actually a probation violation because it was so quickly after his release federally. Even after he was charged in November of of aggravated battery and murder, in this case in March. He continued to commit crimes and to assault people in the Lauderdale County Jail as late as July of this year. On page 14, he was given the opportunity to participate in juvenile mental health court following a burglary conviction, but he was non-compliant and violated the supervision standards and JMHC rules. One violation occurred in 2018 when a video showed Mr. Broncho threatening another client and waving a gun. While incarcerated as a juvenile and as an adult, Mr. Broncho frequently lashed out while exhibiting violent behavior towards correctional employees and fellow residents. The December 2018 conviction we talked about earlier was while he was in custody at 3B and hit a corrections officer in the face. Currently, Mr. Broncho is in violation of his federal probation for absconding and committing the instant offense. They are waiting to see and deferring, in their words, to this district court for sentencing. On the bottom of page 15, when he talked about the additional felonies, he says, when I got charged with assault, it was the result of feeling disrespected, and I overreacted. I asked the officer to not disrespect me, but he kept doing it. I have become so institutionalized that I'm not sure how to act in regular society. Page 16. At the time of examination, this is Dr. Lander's report, page 2, the defendant remained indignant towards correctional staff behavior that led to his decision to be violent, and without remorse, stating justification based on criminal thinking errors. The examiner would recommend high security measures into the foreseeable future. Page 3, I read that before about the engaging in violence in the prison system. He was received increased management. There was placement in special housing. All of this occurred in what was a relatively short sentence of 14 months for stabbing an individual multiple times in the community. Continued to display violence in the absence of remorse or victim empathy during his current incarceration. Should he be released to the community at some future point, there is no reasonable expectation that he will demonstrate a reduction of risk for continued violence. Page 4. No reasonable expectation that he will demonstrate a reduction for risk for continued violence. Page 4. His insight into his overall condition is poor. His ability to perform proper judgments is impaired as a result of his antisocial, normative, cognitive, and behavioral patterns stemming from an unusually dysfunctional developmental learning history. While he denies dangerous ideation towards self or others, proximal and distal indicators would be most consistent with a high chronic risk for such. There is a chronic and high risk of dangerousness to self and others, though imminence at this point is not evident. The long-term risk for future violence in the community being high. Page 5. Successful treatment will require the defendant to adopt new behavioral and cognitive patterns that can be assisted through application of skills-based psychotherapy, but ultimately that requires motivation and commitment to develop prosocial skills on the part of the defendant. This motivation and commitment to change is not currently present. His risk of reoffending over time without adoption of entirely new patterns of thinking and behaving is high. Current indications are that he is not motivated for change. A rational evaluation of all available data leads to the conclusion that his risk to the community will remain high indefinitely. So I'm not focused on any parole board in the future. I'm focused on my duty, and today we must be focused on the courts. And the responsibility is this court to protect this community. The difference between a 20-year-old, 22-year-old at 25 years and 35 years is significant. But ultimately, the question is not, how are we going to best serve the needs of Lance Broncho? Ultimately, we're talking about families that are unaware that he even exists, and that don't even exist yet. And that's the duty of this court. So we ask that the court, considering all of these factors that were put forth in the PSI, to require that the defendant serve 35 years before any eligibility for parole. The court didn't have the opportunity to see any of the exhibits during the prelim. I have one, and I think we have a stipulation that the court can consider that. I don't know if the court would like to just watch that. It doesn't need to necessarily be published. It's something that was released publicly in the past. But I think it's important for the court to understand the nature of who we're dealing with. This was Exhibit 1 in the state's preliminary hearing.
All right, Mr. Archibald.
Your Honor, I understand what the state submitted at the preliminary hearing, but we did have a dispute at that time about what was actually said during this phone call, but I don't object to the court observing it.
All right. All right, well, I guess let's take a couple of minutes recess. Let me review that.
Well, Judge.
And then I'll come back and we'll consider it at that time. Once you hand that to my marshal, we'll take, how long is this, Mr. Neal?
It's very short. Very brief. A few
Less than a
sentences.
minute?
Less
Couple of
than a
minutes.
Less than a minute.
All right, so we'll say 5-minute recess. That'll give me enough time to get out of here and turn on my computer.
All rise, please.
On the record in State of Idaho versus Lance Jonathon Broncho, CR 10-24-2407. I took a 5-minute recess to review State's Exhibit 1, which was a recording of a video telephone call between Mr. Broncho and third parties. So I have reviewed that at this point.
Thank you, Judge. In addition, I know the court was provided in the pre-sentence investigation report with a pretty lengthy number of police reports. Included in those materials were excerpts from jail phone calls. And I hope the court has had an opportunity to see some of those, because it's easy for the few minutes that you're in front of the court to put word a certain picture that you want the court to think. One of the things that stands in stark contrast to the evidence which was presented at the prelim was that 4 individuals were in a vehicle together. They parked approximately a block away, and Mr. Broncho left alone and came back injured. Throughout the report, there seems to be a refusal to accept responsibility, even though during that preliminary hearing, both Gina and Ormed testified that they recognized certain distinctive features about the one individual who came in and was responsible for the shooting. Throughout those jail phone calls, there's an attitude that's displayed that he's almost amused. And I think it reflects exactly just the callous and casual nature that Mr. Broncho has towards violence, towards being a member of a gang, or living a lifestyle where he embraces violence when he's disrespected, or when he comes into a situation where he feels like he has to strike out. So there is agreement, Judge, that that the potential that is that Mr. Broncho would never be released. That is agreed upon as an indeterminate sentence. But given the nature of this offense, given the nature of Mr. Broncho's present condition, his current lack of desire to change, his current lack of acceptance of the accountability for what he did, no one else, Lance Broncho did. These are all things that the factors that the court has to consider scream out for a 35-year fixed sentence. So we would ask the court to impose that.
Thank you, Mr. Newton. Mr. Broncho, before I impose sentence, you have an opportunity to make your own statement directly to me. You don't have to make any statement at all. I don't place any negative meaning or inference on any defendant who chooses to stay silent at this stage of the proceedings, but if you want to, now's your opportunity. Do you want to make a statement directly to me?
The only thing I want to say is I accept responsibility for whatever you give me.
All right.
Accept what you give me.
All right, thank you for those comments. Mr. Broncho, are you fully satisfied with the representation Mr. Archibald and Mr. Thomas have provided?
Yes, Your Honor.
Mr. Archibald, any legal reason I should not impose sentence today?
No, Your Honor.
All right. And Mr. Broncho, could you please stand for me? Mr. Broncho, based on your previous plea of guilty, it is the judgment of this court that you are guilty of murder in the first, in violation of Idaho Code 184001. We're also guilty of aggravated battery with the use of a deadly weapon, violation of Idaho Code 18907. In preparation of today, I looked at the entirety of your file. That includes the pre-sentence report. That also includes anything else that was filed with this court. For every sentence, the court must keep in mind the objectives of sentencing, and those objectives include punishment, rehabilitation, protection of society, and deterrence for you and others. I also have to look at Idaho Code 192521, which includes factors as to reasons why a court would impose a prison sentence. Given the murder charge, you have to face at least a minimum prison sentence, but just so you understand those factors include that prison should be warranted when a lesser sentence would depreciate the seriousness of the defendant's crimes. Imprisonment would provide an appropriate punishment and deterrence for the defendant and others. Imprisonment would provide appropriate opportunity for the individual who has found himself multiple offender, or what's called a professional criminal. When I looked at your PSI, I'm going to note some things that have been brought up either by your attorney or the state's attorney. You really do not have a significant adult record, but you haven't been an adult for very long. You do have a significant juvenile record. As your own attorney indicated, it started when you were about 13. You have spent significant time incarcerated. You yourself made the comment, as referenced by Mr. Neal, that you're institutionalized. You don't know how to act out in public. You have a felony conviction in federal court. You're currently on parole. You were on parole at the time of these crimes. And you also have pending 4 felonies, all of which were alleged to have occurred after the crimes in this matter, as referenced by Mr. Neal. They all occurred while you have been incarcerated in Bonneville County Jail. You were only 23. In my mind, that's a mitigating factor. Science has told us that the brain doesn't really fully develop till you're 25. That is not an excuse, Mr. Broncho, but it's a reality that young people have to work harder. You didn't take advantage of some opportunities that you had while incarcerated before. You have an LSI score of 42. A little bit more on that. Basically, those are questions that are posed to you. It's an actuarial table. There's a statistical correlation between that number and the likelihood that somebody would commit a crime in the future. The higher the number, the more likely it is. And you're sitting with a very high number. And I don't think that's a surprise to you given your brief life. The largest aggravating factor, in my opinion, is although we talked about you don't have much in the way of an adult felony history, your history just speaks of violence. The crimes that you've been charged with and that you have been convicted of typically are the violent crimes. You had, going back to your juvenile record, you've had a weapon while on school grounds. You have burglary charges as a juvenile. A couple of those. And battery on certain personnel while you were incarcerated. The federal prison term, as indicated by both counsel, involved the stabbing of another individual. And your pending charges also include claimed, not proven yet, but claimed batteries on certain personnel. You were non-compliant with prior probationary terms. You wound up in JCC for that. You were only released on parole August of 2023, and within a half a year, you're involved in this crime. I have concerns with respect to taking responsibility, Mr. Broncho. I know you're saying you take responsibility. In your PSI, you indicated you took responsibility, but I gotta be honest, you did it kind of in a roundabout way. Your version of events talk about having an acquaintance that you knew from prison to whom you owed a favor. That was the individual who came in the front door, you were in the back door. That was the individual who pulled the weapon. You did take responsibility in your version by saying you were the one who provided the weapon, you were there. So there's a measure of responsibility, but your version of the events, Mr. Broncho, is the only version of events that was ever propounded that involved this other individual. Neither of the victims indicated there was another individual. The other individuals with whom you were with that night all indicate you went into this building alone. So while you take somewhat responsibility for your involvement, it is a measured responsibility because you seem to still be promoting a story that I find incredible, that there was another individual involved. Your history includes acting out because you felt disrespected without any check on your emotions and trying to find a different way to act. You have mitigating factors. It is clear that your upbringing I would not wish on anyone. You don't set the table at the beginning, and opportunities you might have had just don't exist. You do have some support. Your mother apparently is very supportive of you, even though while you were growing up, she herself was struggling through the system. But you do have some family support. Indicated you've expressed some remorse. You do have long-term mental health issues that were outlined by Dr. Landers and indicated by your own attorney, which includes PTSD, some indication of auditory hallucinations, paranoid delusions. You do have substance use as indicated by Mr. Archibald. And again, all of those starting when you were at a very young age and continuing on. I found it interesting, Mr. Broncho, on your values and outlook, that you indicated that children are innocent, need to be motivated to do well and do the right thing. You're 100% correct. Again, you weren't given some of those opportunities, but you sit here as an adult and you had terms in incarceration as a juvenile. The hope was that you would take advantage of those opportunities. You also indicated you want to be a role model to kids going down the path you did. I think that is commendable. Mr. Broncho, we were all role models at all times. Right now, you're not a good one. You are a role model. I'd like to think maybe you have an opportunity at some point in the future to get your story out there. I'd like to think you have an opportunity to start that today. But so far, you haven't shown the court that you want to make that change. And again, the most telling for me is if I were to believe the allegations of the other pending charges, you have not been a role model prisoner. In fact, you've been quite the opposite. You've placed yourself in a situation where you just continue to show your violent tendencies. The state picked up on things I picked up on with respect to Dr. Landers. You continue to display violence in the absence of remorse of the victim, empathy during the current incarceration, defendant unwilling to commit to change at this point. Individual will likely continue to display patterns similar to the past, will likely experience the need for high levels of management and security while in prison due to continued violence. The outlook for you, Mr. Broncho, is not very good as we sit here today, and I must focus on what I have today, with the biggest piece being the protection of society, because as you stand before me, you are violent and dangerous, just given your own history. The best way to protect society, obviously, is incarceration, and you also understand that because you yourself agreed that at a minimum I should sentence you to a 25-year determinate period of time. So I take that as a recognition of what you've done and what should happen. With all of that being said, Mr. Broncho, it is the judgment of this court that you be sentenced to the custody of the State of Idaho Department of Corrections as follows. For count 1, murder 1, for a minimum determinate period of time of 35 years, with an indeterminate period of time of life. For count 2, aggravated battery, that you be sentenced to a minimum determinate period of time of 10 years, followed by a 5-year indeterminate period of time. Those sentences will run concurrent. Will impose fines in count 1 of $10,000 and in count 2 of $3,000. You will pay court costs. You will order. There was a motion for restitution that was filed with a total amount of $73,858 $1,022.84 with a request that it be left open for future medical expenses. We'll order that restitution in that amount with the proviso that it will be left open if there are additional restitution requests. If there are additional future restitution requests, Mr. Broncho, you will have the right to have a hearing on those. I won't just automatically impose them, but I will leave it open in case there are more out there. We'll issue a civil penalty of the amount of $5,000. Reimbursement to the county or state for public defender services in the amount of $1,000. Mr. Broncho, do you have any questions about the sentence I have imposed?
No, Your Honor.
Mr. Archibald, is there anything I said that needs to be corrected or clarified?
No.
Mr. Neal?
Victim relief and court cost.
Victim relief was $5,000 and court costs were also ordered. I just didn't order the amount of court costs because I don't know what they are. They will be the standard amount. Anything else?
Nothing for the statement.
All right. With that, Mr. Broncho, I need to advise you, you have the right to appeal my decision. You have 42 days to file that appeal. If you think my decision is illegal or too harsh, you have the right to seek relief under Idaho Criminal Rule 35. You have 120 days to seek relief under that act. You can always seek relief under the Idaho Uniform Post-Conviction Relief Act. You have 1 year after your appellate rights expire to seek relief under that act. You have the right to have an attorney assist with all of those appeals, and if you cannot afford one would be appointed. You understand your appellate rights?
Yes, Your Honor.
Do you have any questions about what we did here today?
No, Your Honor.
Mr. Archibald, anything else in this matter?
No, thank you.
Mr. Neal, anything else in this matter?
No.
With that, Mr. Broncho, I will,
Just a quick question. On the $1,000 public defender fees, do you want that split between the two charges or just?
just,
Okay. Thank you, Your Honor.
all right. With that, Mr. Bronco, I will remand you to the Bonneville County Sheriff. He will eventually turn you over to the Idaho Department of Corrections to serve your sentence. With that, we will be in recess on this matter.